Alright, guys, buckle up because this opening sets the tone immediately. The narrator introduces a brand new courtroom and a judge who clearly does not play games. From the very first seconds, you're told this case involves a Karen whose behavior crossed the line into criminal harassment. What really hooks you is the promise that this judge has absolutely no chill, yet still runs a fair courtroom. This intro isn't filler, it primes you to expect firm rulings.
This is Dean Chavez, 22T1470. Good morning.
Good morning.
All right. And then probation is here on this one. All right. Okay, probation, want to tell me what's going on with Mrs. Chavez?
Yes, Ms. Chavez. Well, I'll tell you what I'm gonna recommend, that we close it out unsuccessfully.
Okay, so it looks like she did not submit to 26 UAs.
Correct.
She didn't get her treatment done. And she missed probation appointments. And she didn't report to sober living. Okay? And so you just want me to close it out with
With jail,
with jail.
yes.
Okay, all right.
And we have an agreement with the DA to revoke and close this unsuccessful with 60 days jail, and that's what Ms. Chavez would like to do today.
60 days with all of that. And this is the first?
I believe it is.
She's looking at up to 364 days of jail. She did not stay in communication with probation. She didn't do UH, which tells me she probably was under the influence. She didn't do any treatment. I mean, honestly, it usually takes at least 10 months to do the treatment that she was, actually more than 10 months. And she got level 2 and 86, which makes me think that this was not a first DUI.
This was a 2022 case, so this one's been going on for a while.
So the 22 case, we're now in 3 years later. And we're gonna give her 60 days when she had essentially almost 3 years to get this done. I would commit a DUI if I could only get 60 days and I didn't do anything. And I didn't know UAs and I did nothing. And then I didn't go to super, I did nothing. And potentially was drinking and having a good time for 3 years.
But one good thing, she did complete her community service. She did that back.
She did community service. She had level 2 and 86. Community service was only 48 hours. You do community service in 48 hours through sleep. She didn't show up to probation, which is the easiest thing in the world to do. She didn't go to sober living. She didn't do any treatment, and she didn't show up for a UA. And she gets 60 days? No, thank you. I'm not taking that. I do think jail is appropriate, but 60 days is not enough. Go back to the drawing table. Don't ask me about it. You can leave it open to me, or you come up with something better than 60 days. But when you do all of that, which means you essentially did nothing, no. And this is 3 years old? No. 6 days, not enough.
Your Honor, there's 2 updates I'd like to give you on this case. Defendant did have 1 prior DUI from 2017.
Oh, so Burns. Oh, no.
And her BAC, and the first one was .212. Also, she had 86 hours of UPS in this case.
Yep, no. Y'all go back to the drawing board. I'm not doing some crazy stuff. We're on a second. And we didn't do nothing? Oh, no. Next, investigation. Have we figured something out?
Yes, Your Honor, I've spoken with Ms. Graham and Ms. Chavez, and we've come to an agreement to revoke and close unsuccessful with 300 days jail.
With who?
300 days.
That works. The court is accepting your admission to your violation of probation. Court is closing out your case unsuccessfully with 300 days.
Alright, guys, this is where you instantly understand who's in charge. The judge listens to the probation summary and completely dismantles the proposed 60-day jail deal. She points out every failure, missed treatment, ignored probation, skipped UAs, and makes it clear that coasting for 3 years won't be rewarded.
Because you have a class 2 misdemeanor, so what do you want to do with that? How are you gonna handle it? Are you gonna represent yourself?
Yeah, I'm represent myself now.
Have you talked to the military about how this would impact you if you were convicted? Yes. Because it could end your career. You sure you don't want to get representation?
Yeah, I get representation. Yes, ma'am.
Okay, because I'm looking at you, and the reason I'm saying this to you, sir, is because my father was an officer in the military, and he was over a lot of airmen. and things like this can get you in your military career if it goes the wrong way for you. So I think you should probably apply to the public defender's office at the very least and find out if you qualify. Okay? Why did they do this case too? 25M5162.
I don't
I
know.
don't understand why the division didn't handle all of her DD cases and wrap them all in deferred.
Your Honor, it's because they moved the case from the district court to here.
That makes zero sense to me. Because Division One should have handled all of her DD cases. All of those cases that she got the deferred sentence on were DD cases, probably involving the same victim. So it makes zero sense that she had a public defender, probably in felony court, that didn't get this case wrapped in with the other cases. That makes zero sense to me.
I'm not sure if she pled guilty.
She did plead guilty.
I don't know if it's a deferred sentence or not.
And
So that's what I understand. Like, to me, it makes zero sense that she pled guilty on 3 DB cases literally this week. And they didn't take care of the last one.
I agree. And the notes say that we're on notice to address bond today in this case, in county court. I don't know.
This just doesn't make any, and is it the same victim on all 3 cases?
yes, Your Honor.
That's incompetence.
I'll talk to the DA in that division.
That's absolute incompetence on both sides. Ms. Woolton got screwed over.
We agree.
This is my branch.
They told me.
But if they're going to give you and plead you on all your cases, but at least one, and then have me handle it, that makes zero sense. But they're willing to give you the first on those, then I don't know why they didn't just wrap this one in there too.
I don't believe it was a deferred sentence. I'm looking at the plea agreement right now.
It doesn't matter what it was. They should have wrapped this in it. It's incompetence. I'm giving you a PR bond because this is ridiculous.
Thank you, Your Honor.
Thank you. Because it's just dumb. I'm gonna keep it real honest with you. You are young, okay? I like the fact that you've got a job set up, and I like the fact that you're going to school. What I don't like is that you're driving. It is clear to me, and it should be crystal clear to you, that you don't have a driver's license. You take a bus, an Uber, or get a ride. But if you get another case, understand. You will stay with us for a long time. I will find you be, don't talk. I'm talking. I will find you be in direct.
Alright, guys, this segment flips the script and shows why this judge commands respect. Instead of punishment, she shows genuine concern for a self-represented defendant and explains how even minor cases can derail a military career. She openly criticizes prosecutorial mishandling and calls it incompetence, something you don't see often. Yet she doesn't humiliate anyone. She fixes the problem by issuing a PR bond and offering guidance. This moment proves her firmness isn't cruelty. It's structure, fairness, and a judge who actually pays attention to real-life consequences.
My first with you, Mrs. Walker. Ms. Walker, you have to control yourself, okay? You cannot have these outbursts that you're having. I'm trying very much not to pay attention to you because I fear that if I pay attention to you, that I will draw attention to you that I don't want to draw, okay? The jury is watching. You need to control yourself, okay? If you cannot control yourself, Miss- I understand, Ms. Walker, I understand. Ms. Walker, I understand. Listen, Ms. Walker, I understand that this is highly emotional for you and there's a lot of emotions going on with you. But I am requiring for you to control yourself. If you cannot control yourself, then I will have to use other means, and I do not want to use those means to control you, okay? So, you're gonna have to control yourself. All right, so a couple of things I want to talk to you about before you take a lunch break. And before you go on a lunch break, it probably will be good for you to have a little lunch. Everybody have a seat, let's have, the arguments.
Yes, Your Honor. The people would be asking for the defendant to be remanded today for 60 days. Then we'd ask for 1 year of supervised probation with a mental health evaluation and substance abuse evaluation. We'd ask for the defendant to comply with recommendations from both evaluations. The defendant's behavior since the verdict over the last 15 minutes has been very concerning to the people. The defendant, I heard her say she said, fuck, shit, goddamn, 1,000 times, not 1,000 times, but probably close to 100 times. She was yelling in the hallway. I asked counsel If they needed assistance with the deputy to help keep her under control, they said they didn't. She called the victim a bitch. She said, "Fuck that bitch." She also said, "Thank God my mom isn't here because I would have killed that bitch." The defendant's disrespect for this court and lack of remorse is concerning for the people. The victim is concerned for her own safety after this verdict. And so we'd also ask for a no contact order between the victim and the defendant. We are very concerned for the victim's safety and for the safety of this family.
Okay, and then, what's her criminal?
A controlled substance F4, and I think she has a couple of misdemeanor convictions within the state. I can pull them up real quick, but I looked at them earlier today.
All right,
She has several charges for, sorry, let me look it up.
all right. And Mrs. Taylor, did you want to address the court in any way as the alleged victim? You can come on out. The deputies are here, so you're safe.
Honestly, I just want my sister to get help. I don't want in contact with her or have her in close to my home or anything like that. I just want her to get help and to stay away from me and from my home and from my children, including my niece who's been living with me for 3 years.
Okay, and how old is your niece?
She's 19.
She's 19.
Well, she'll be 19.
She'll be 19,
Yes.
okay.
Yes.
And in terms of what you know about your, sister, when you say she needs help, does she have like some mental?
I think it's undiagnosed, honestly. When she's not in this state of mind, she's like this good person, but then anything sets her off, and it's a nonstop situation of calls, voicemail, text messages, not only to me, but to her own daughter, degrading, disrespect, threatening her life,
You need to be
disrespecting,
quiet.
threatening our lives, threatening my children's lives who are 8, 7, and 2. I work from home, and my husband's always scared to even leave because.
All right, guys, this is the calm before the storm. The narrator pulls back the curtain and explains that the upcoming trial lasted over 6 hours, but only the most explosive moments are coming. You're told straight up that this defendant is about to crash out in front of the judge. That warning alone builds anticipation. By the time the sponsor segment ends, you already know this isn't going to be a quiet sentencing. The stage is set for emotional collapse, courtroom control, and consequences that no one in that room can avoid.
That's what we're at.
All right, I appreciate it, thank you. Mrs. Jacobs, your argument? Mrs. Walker, I'll give you a chance to talk when I get there.
Okay, we'll get there. So Ms. Walker's been working at In-N-Out for about a year and also works at the Hilton. So she's working 2 jobs right now. She's been doing the Hilton for a couple of months. And she's still experiencing homelessness, but she's been trying really hard to get back on her feet. In-N-Out is willing to transfer her and help pay for moving expenses. So she's been hoping to keep up working both jobs for a while, and she's been saving. Because she does want to move away from this area and move away from the troubles she feels she's been experiencing with her family. It's my understanding that In-N-Out gave her the okay to move anytime, but she's been staying because she's been wanting to get this case resolved. So she's really hoping to get out of the area to be able to get her life on track, away from her family, and kind of start over. And jail would set her back in that progress that she's been making. I also believe jail is not warranted. I understand the jury found her guilty, but at the end of the day, this case was about a voicemail. She's not charged with and not convicted of a violent crime. And it seemed to have arisen from an argument over her daughter's care, who is now 18 years old and a legal adult. So I believe conflict over her daughter's care is unlikely to repeat itself since she's legally able to care for herself. I did not hear her say anything, any kind of threats about killing her mom, and I was sitting there in the hallway with her. So I don't know if she misheard it, but I don't think all of that was accurate.
Okay.
We are asking for a year of unsupervised probation with the mental health evaluation and treatment, which was the last offer on this case. And I believe based on our investigators' conversations with Ms. Taylor and with Ms. Walker's mom, and based on what Ms. Taylor said, I think help is really what her family was hoping for. So I think mental health is more appropriate. I believe asking for jail at this time after we went to trial is something of a trial tax in this situation. And so we are asking for just the probationary period and the mental health evaluation.
Yes, Your Honor. I just pulled up the defendant's record. She has two guilty pleas and violation of protection order in two different cases. They were felony cases, but they were reduced down to violation of protection order. She also has a guilty plea to an M1 menacing. And that's what I could find. I also heard the defendant say in the hallway that if she gets supervised probation, that she's leaving the state.
All right, guys, here's the first visible crack. The judge directly addresses Miss Walker and warns her that the jury is watching everything. She explains that her outbursts are hurting her case and that continued behavior will force the court to intervene. The judge's tone is firm but measured, almost offering one last chance to regain control. This moment is crucial because it removes any excuse later on. Miss Walker is clearly warned, clearly understood, and clearly on thin ice as the courtroom tension tightens.
Mrs. Walker, anything you'd like to say?
I just think it's a bunch of BS because I called DHS and they were the ones who told me to keep calling until you go home with your daughter. I just got into a car accident September 1st. I found out that my Medicaid was out. So I needed my daughter's birth certificate, social security card, which my mom should not have had in the first place. I only gave it to my daughter so that she could get a job. That is the reason why I was calling. I was not calling for any other issue, not that I had a problem with her. I was specifically calling for my daughter's birth certificate and social security card. My family has been taunting me with my child for years. And they are doing that so that I can't spend time with my child. So to keep putting me in a worse situation, I just got a card. That's why my sister's here. Because in February, she's texting me. Oh, sorry. In May, let me sit next to you. My daughter's graduation, she sat right next to me. And she's here in August. So it's not, she was never scared, never afraid. They've always been in my face. It is me against them. And they are taunting me so that they can keep me away from my child. And I'm fed up with it. They have allowed my daughter to disrespect me. And when I go to them about it, it doesn't matter. But as soon as my daughter disrespects them, it's game time. So they allow my daughter to disrespect me and thought it was funny. That's what she's talking about. They're sitting up there right next to my daughter while she's calling me bitches and this and that because she's upset. And they're just laughing. We'll just see what she does. I called my sister specifically to get my daughter's birth certificate. Sorry.
She can't, there's my.
To get my daughter's birth certificate and social security card so that we can get her Medicaid. Someone had just T-boned me and I did not know that we did not have insurance. And I couldn't afford insurance at the time. So I slept in my car from September to November in pain with nothing. I couldn't even go to the doctor. So I'm working in pain after a car accident. I had no car, no nothing. So it was up to me if I was just gonna sit there and die or get up and do something. And they keep taunting me. Every time I get a little bit ahead, let's do something else. Let's do something else. Let's do something else. Let's do something else. They had a graduation party with my daughter's father in, May?
Yeah.
They got it all on Facebook and everything like that, trying to taunt me. That's not okay. You're starting more problems. You're not scared. If you're scared, then you're scared. How are you scared and starting more stuff? And then I just seen them at Burlington. My mom was like, Chelsea. I turned my back towards her. She called my name again, and I gave her a hug. But it's lies. She's
All
just
right,
here 'cause-
guys, this is where the case takes a serious turn. The prosecutor lays out disturbing behavior that happened off the record, repeated profanity, violent statements, threats toward family members, and open disrespect for the court. The courtroom mood shifts from disorderly to dangerous. The request for jail time and a no-contact order isn't about punishment anymore, it's about safety. Every sentence adds weight, and by the end, it's obvious the defendant's own actions after the verdict may have done more damage than the trial itself.
but this happened in September of last year, and I talked to you multiple times since then. So that's not okay to me. And I went to DA before I even called her phone. I was calling DHS like they have my child. They're not answering. Every time I need something important for my daughter, they like to ignore me. It could be simple as a doctor's appointment. They will not budge. They will not budge. So I feel like, why does my daughter, that's why I said I wish my daughter was with DHS in that voicemail, because I wouldn't have to go through this. Yeah. I'm not gonna go through hoops over doctor's appointments, Medicaid, and all that stuff. My daughter's just living there. She still doesn't have health insurance. They're not doing anything about it. So if something happens to my daughter right now, who's gonna pay for it? She is. She's my daughter is.
Okay.
Because they won't allow, you know what I mean? They're blocking just hiding. I'm better. I don't know. It's just.
I understand, Ms. Walker. This is the thing. I really had hoped, hearing what the offer was unsupervised probation with mental health. I really wish you had taken that offer, because I do think you need some treatment. But the problem that I'm having with you, Mrs. Walker, is a couple of things. I watched you during this trial. And I think I had to admonish you during this trial about the things that you were saying under your breath and the things that you were being aggressive about. Yeah. There was a concern. And how you were doing yourself a disservice in this very trial.
Yeah, because I've been through a lot.
Ms. Walker, I'm talking now.
I'm just tired of it.
Ms. Walker, I'm talking now. And I understand that you're tired of it. But there's a way that you have to respond. And there's a way that you have to act.
Like I just had
that allows you to not have to have police interference. And the problem is, not only in that voicemail did you talk about your daughter, but you also said some things about wishing harm on people and wanting to continuously, essentially, Ms. Walker, you're the one on trial. They're not. And that's the problem, is that I don't think you have any understanding of what your actions were and the ramifications of your actions, and how your actions has caused distress on your sister. Okay, Ms. Walker, I'm not gonna be interrupted again. If you wanna interrupt me again, that's fine. I'll have you removed from this courtroom and I'll sentence you without you being present. And then your lawyer will have to come down to the jail and tell you how much jail I gave you. But do not interrupt me again. This is the problem, Ms. Walker, is you need help. You need anger management. You need mental health. I don't know if substance abuse is your issue or not. I really don't know, but I don't think it's a bad idea for you to do a substance abuse evaluation, because maybe your mental health is tied to that. I don't know. But what I do know is I do think it's appropriate for you to do some jail. And I'm concerned that after you were sentenced, I'm not upset about the fact you being upset. A lot of people would be upset that they were convicted of the charge that you were convicted of. The problem that I have is that the words that you said after you were convicted and the statements of potential threats to other people again. And so that tells me that after you have gone through a trial of a full day where you were accused of threatening your sister, that you didn't really quite get anything from that experience in terms of remorse. And so I do think it's appropriate for you to do jail. I am gonna put you on supervised probation. I think it's appropriate to put you on supervised probation for a year. I am gonna require a mental health evaluation for you to follow recommendations of that evaluation. I'm gonna require a substance abuse evaluation for you to follow recommendations of that as well. I do think it's appropriate for you to do anger management course. In addition, I am gonna give you jail. I am gonna give you jail of 20 days.
Well, I'm gonna lose my job. I just got my car. I'm gonna lose that.
All right, guys, this testimony hits hard. The victim doesn't ask for revenge, she asks for peace. She describes constant harassment, fear for her children, and the emotional toll of living on edge in her own home. What stands out is her restraint. She wants help for her sister, not destruction. That sincerity cuts deep. This moment reframes the entire case, shifting it from legal arguments to real-world harm. You can feel the courtroom absorb the reality that this behavior has left lasting fear, not just hurt feelings.
And I'm hopeless. I don't have anybody else to help.
I understand that, ma'am.
So I'm gonna lose everything, and then I'm gonna be out, and then nothing's gonna change.
I
You guys are putting my daughter in a worse situation now.
I've given you the sentence.
I know, but what I'm saying is,
And you work
For
for
this
what,
even start-
Ms. Walker, I'm asking you a question. I need you to
Yeah.
stop interrupting me.
Mhm.
What days of the week do you work?
I work, it's random.
It's
Work
random. Do you work full
Sunday.
time? Are you a full-time worker?
I work 32 hours at In-N-Out and then 12 hours on the,
But then this is my question to you, because I don't necessarily want you to lose your job. I'm willing to give you that time as week in jail, but you're gonna go into custody.
yeah, I
Okay.
can't. I
And
just
so
don't
I don't know if
understand.
you can do it on the weekend, and you don't work Friday, Saturday, and Sunday, but you're going into custody now. If you wanna do a portion of it as in-home detention, I'm amenable to that. But I think you need to do some time.
I don't because you guys don't understand.
Well, then I'm not
I
gonna
just
have
have
to
to
base
say
you.
one thing.
So it's gonna
No,
be
I just
20
want to
days
say-
in jail. I'm not gonna do weekend jail anymore. I'm not gonna give you that
I
option.
just wanted to say
And now
something
you're gonna-
because I'm always being treated bad. Okay?
I'm not treating you
So
bad,
this
ma'am. I'm trying to have a conversation with you, and I was trying to work it out.
to-
I was trying to work something out with you so you didn't lose your job. And instead, what you want to do is continue to interrupt me and tell me about how you're a victim.
No,
What I
I'm
was
not
trying-
saying that
what
I'm
I
a
was
victim.
trying
I'm
to
just
do,
saying.
ma'am, what I was trying to do was give you an option, so that you didn't have to get remanded today, and you're not giving me that option. So I'm taking away that option now, remanding you for 20 days. When you get out of custody, you report to probation within 24 hours, supervised probation for a year.
Wait, hold tight. Your Honor, Ms. Walker does want to appeal this case, so under Rule 37F and 16-2-1146, we are requesting a stay of execution on.
She can have a stay of execution, but she's going to jail today for how she behaved.
So,
I
Your
was-
Honor, hold on a second. I don't think you could just take her into jail today for how she behaved. What's the basis for that?
The basis is her behavior and the way that she behaved in this courtroom and her lodging threats afterwards. So I'm absolutely taking her into custody.
I don't understand though. Is this a new?
It's not if you don't understand.
I think we
I'm
need-
finding her in contempt of court.
I just wanted to.
And so I am taking her into custody. I also am concerned for the victim in this case and the witness. Potential witness was gonna be Vanessa, who is the mom, who she made a threat against in the hallway. So I'm taking her into custody.
Give me just a minute, Your Honor. I think there's a record that needs to be made about the contempt situation. I'm just pulling up my documents on that.
We can address this on Friday. I'm taking her into custody. We can address your record in terms of contempt on Friday at 8:30. But I'm taking her into custody.
No, Your Honor, I think, hold on. Let me just find it.
I really want to avoid jail, but it's just not, it's not gonna work.
I just literally had someone file a false police report of me last week.
Ma'am, I want you to get help. I really do.
Saying that I literally was doing nothing. Okay, I'm homeless, so on my days off, I go get a hotel when I can to sleep because I get tired of sleeping in my car. It's
I
not
really
fun.
want to help you.
So what I was doing, all I was doing was taking a picture of myself. Someone called and said that I pushed it. So the cops came
I
out.
have it on Thursday at 8:30. That's closer.
And so I've been dealing with a lot of this. And what I'm saying is that my stepdad has also lied to the police in my face. While the police were there, and they didn't charge me, they told me I have to stay, that my mom could not put me out for another 30 days because they didn't see any of the things that's happening. So what's happening is that I'm being falsely accused of a lot of things that should not be right. Like, she shouldn't have my daughter.
Ma'am, I'm not here to discuss your daughter. I'm here to discuss the conviction that you just got.
Exactly. So what I'm saying,
Outside of my courtroom.
I just don't think that this is fair.
I
I just don't
understand.
think it's fair because I've been going through a lot and it's just me.
Your Honor,
I understand.
which element of?
It's just me by myself working 2 jobs, trying to stay off the streets, and you're trying to put me.
Alright, guys, this is the unraveling. The defense tries to minimize everything as a voicemail dispute and argues jail would be unfair, but the damage is already done. When Miss Walker finally speaks, she confirms every concern raised against her. She blames everyone else, justifies the calls, and shows no accountability. Instead of calming the situation, she escalates it with emotional excuses and accusations. By the end, It's painfully clear that probation won't fix this. Her own words seal the outcome and validate why the court had to step in.
Ms. Jacobs?
I'm just like, Your Honor, can you make a record about if this is a direct or indirect contempt and which statute you're doing it under?
Or can you please just give me, I'm making it a record that this is indirect contempt.
I can't, you know what I mean? It didn't have to be a company, and I
I had already acknowledged and had admonished her prior to the jury being dismissed, or after the jury was dismissed for lunch, about her behavior. She continued to make threats to have inappropriate behavior outside of the courtroom. She has interrupted this particular court when this court has asked her to
I said
please
that-
stop. She's still interrupting me at this very moment.
all I said was that.
And so the court has tried over and over again to work with Mrs. Walker, and Ms. Walker is not doing it. And so the problem is that we're having here is that she is continuing to defy the court's orders. Court's orders to continue to be quiet. I've asked her over and over again not to speak. She is in direct violation of the court's order to be quiet, to have decorum in this courtroom, and she is not having it. So I am finding her in contempt of court. And I am taking her into custody. We can bring this back onto the docket on Thursday at 8:30 to discuss her sentencing and the continuation of her sentencing and your record for appeal. But I am finding her to be in contempt.
I have no one else to take my card at the.
Yep. Until Thursday. On Thursday, we can argue bond.
Not fair. This is not fair.
What Thursday, what's the last thing we have on Thursday?